the point is that part of the point is that not all contracts are written up by lawyers in conference rooms. That a lot of contracts law just happens, and it happens while people are doing business. Sometimes they don't even think they're doing business, but things happen in conversations. And the question is, if you're just sitting around talking, and a lot of business happens this way. People are playing golf on the golf course. People are having dinner together with their clients, or worse yet, they're out drinking and they're drunk and they're talking. Who knows what they might say? Or they're sitting in the sauna at the Premier Palace and they're relaxed and they're talking. And you see in these cases, people say things they don't necessarily think, I'm creating a contract. But you see that in these cases that issues arise about whether they're bound by what they said. If what they just said in a casual setting has created a binding and enforceable promise, and you need to know that as not only as an attorney, but just as a person walking around, whether you're saying something that you might be held to later, that might be a binding promise. And so we saw that with the Neuhoff case. Remember the window case? The inspector comes and says, oh yeah, these windows are bad. We'll replace 30 of them now. We have a production problem, we'll replace the rest later. All of a sudden, that becomes a contract dispute. And you understand, they weren't sitting around writing this up in a conference room. And also the important thing about that case is that it introduces the idea that we'll study more later on. You know, contract law in the United States is mostly a product of common law, which means it's, you know, all these cases that have developed over time, going back to England. But in some areas, it's more like Roman law, might be more like European law or Ukrainian law, where it's governed by statutes, because they mention that in the Neuhoff window case, don't they? They talk about there's a statute that, and it's called, and it's loosely called the Uniform Commercial Code. And the way these things work in the United States is groups of lawyers get together and study these issues about whether they should write up some legislation to govern an area of law. And they write what's called a uniform code, which is proposed to all of the states. Because remember, most law and most contract law in the United States, it's not like one law for the whole country enacted by the Congress in Washington, D.C. It's enacted by each of the 50 different states. And so a uniform code is proposed, and it's a model for the states to use. And sometimes they go by it, and sometimes they change it. Sometimes they adopt part of it and don't adopt part of it. So there is such a thing. For example, we've had one case we've had a couple of cases about inheritance after people have died. Remember, there's the aunt who promised her nephew, I'd like to give you $3,000 because I love my nephew. And then there's the family, their father has died, and they open the box and find all the papers and like, who's going to get what property. So there's a uniform code for probate law, which governs those kinds of agreements, wills and trusts and estates. There's a uniform probate code that was proposed by a kind of study working group of lawyers, and most of the states have adopted all or part of that. There's another uniform proposed code like that called the Uniform Commercial Code that governs the sale of goods. And so that would apply in the Neuhoff case, because windows are goods, right? That's a product. Goods can cover anything. If you're selling cars, that's a good. If you're selling lawnmowers, if you're selling apples and oranges, it can cover, any kind of distinct object that you can sell, and it includes windows. And part of the point of that Neuhoff case is it introduces that idea that there is a uniform code that governs your rights and duties when you're buying or selling windows. The other point of that case is that windows are goods that were sold at one point, and so the Uniform Commercial Code would govern the sale of those windows. And that Uniform Commercial Code includes a warranty, a guarantee of the fitness of those windows, that the windows are not going to decay in 2 years, for example. So we don't know what the warranty was, but maybe the windows were, had a warranty saying this window will be good for 3 years, maybe. But part of the point of that case was that that statutory warranty didn't apply because a statutory statutory remedy requires you to follow very certain procedures to qualify, and in that case, one of which the buyer of the window had to give notice to the seller within a certain amount of time that the windows were defective, and it had to be a certain kind of notice. And that never happened in that case because the people who bought the windows, they were not lawyers. They did not know about the Uniform Commercial Code. They apparently didn't consult their lawyer about their defective window. So they didn't know that they had to give a notice of the defect to the manufacturer. And then they had a certain amount of time to do that, and they didn't do that in time. So I think that code required them to give notice within 4 years, and it was 7 years before they started talking about their windows decaying. So the statutory remedy didn't apply. So in that case, they had to fall back on the historical common law remedies. But the point also is, in none of these cases are people really dealing with a written contract that they sat down in their conference room and wrote with some lawyers. All these cases are about, they're talking to an inspector who comes and looks at the windows and says, oh yeah, these windows are bad, we'll replace 30 of them now, and maybe we'll replace the rest later. And then, the question becomes, is that just what that inspector said? Does that become an enforceable promise that the people who bought the windows can sue in court on? When the aunt says, I love my nephew, I want to give him $3,000. The court says that's not an enforceable promise. Why not?
Because there was no consideration.
Because there was no consideration. Of course, what's the other thing you could have argued in that case? That it didn't depend on the aunt's unenforceable promise. Because why? Because what else did she do besides say, I love my nephew, I'd like to give him $3,000? She wrote a note, right? So, which the court kind of ignores and undoes all of that. What other case we have? The family opens a box that's got papers in it. There's not really even a will to go by. There are a couple of deeds, and so but the argument is over. Remember something that Sophie just blurted out. They open a box. There's one piece of paper that gives one property to her and her brother George. And so she's not sitting there with a lawyer writing out an agreement with her other siblings. She just blurts out, oh, well, we won't, enforce our claim in the other property if you don't bother us about this property. And the question is, when she blurted that out, just said that without thinking, without talking to her lawyer, could her other brother and sister then enforce that promise against her? So I know y'all think this all sounds very theoretical and not practical, but actually it's very practical because there's more danger in becoming bound to a promise that can be enforced against you just, when you're talking with your clients while you're out drinking and drunk, or you're sitting in the sauna at the Premier Palace. So so we have so just to review, so when Sophie, without thinking, blurted that out saying, well, we'll give up our claim in that other property, was that an enforceable promise?
No, because she gets nothing.
No, she got nothing for that promise. So there, again, it's back to no consideration. I'm going to give y'all a clue for y'all's reading for the next time. So these cases, they all say they're about consideration. Is there consideration that makes the promise enforceable? And these cases, they also talk about the promise being illusory and whether the promises are mutual. But there's really another issue being introduced, which is not just about consideration, but about contract formation. And when has a contract been fully formed? And again, it's a lot of it based on talk or a form that somebody signed. Notice we're not talking about disputes that arose over a written contract. A couple of classes from now, we're going to look more at formal contracts and how they're interpreted, how the language is interpreted. But all these cases are about somebody just said something, and then can that be enforced against them? Or somebody signed a form, and can that be enforced against them? So I'm not going to get too much into the facts of these cases that are supposed to be for today, Matei versus Hopper and Weiner versus McGraw-Hill, because we're going to do that. We're going to try again to do that next week and try to get the word out. So I'll send the email out again and hope everybody will understand that what I want y'all to do is to write a case brief. Half of you are going to do it on Matei versus Hopper. Half of you are going to do it on Weiner versus McGraw-Hill, and cover these issues about what's the issue in the case, what were the positions of the parties, why did one side say they should win, why did the other side say they should win, what are the facts that determine the outcome, what's the legal rule that the court relies on, and then what's the holding, how did the court apply the legal rule to the specific facts in this case. And we will try again to do that and go through this discussion of those two cases, and then hopefully be able to move on to the next subjects. But since I have a few of y'all, we got up to 22 of you. That's good for the last minute. And thank you, Sophia, for your comment. But while we have a little time, and this is kind of like extra time for y'all, since y'all were prepared to get on the class at the last minute at 10 o'clock. Do any of y'all have any questions about anything that we've talked about today or another day, or something you wish we had talked about that we didn't talk about? Now's your big chance. Okay. Well, if there aren't any questions, we'll try again next week.
Recording in
To do the case briefs on these two cases and discuss them, and then we'll start moving on to other subjects. We'll talk a little bit about employment law and some of the rules of employment law that might be interesting to y'all. usually interesting to people who are graduating from school and trying to get a job. The rules of employment contracts might be interesting to y'all. And if not, I'm gonna go meet with the dean here at the University of Alabama about building up this class and this cooperation between Alabama and Irpin. And if nobody has a question or a comment, I'm gonna let y'all go. I was gonna say early, it's actually late, late at night for y'all. But thank y'all for coming in at the last minute. And sorry again about the confusion about the time.
Thank you for this meeting.
I'm sorry?
Yes, thank you very much.
Thank you
Oh,
for
yeah.
this meeting.
Yeah, thank y'all. Thank all of y'all. And I will see y'all next week, and we'll all be at the right time, and we'll all have our homework done, and so we can discuss it. All right, thank y'all.
Okay.
Okay, we try.
All right.
Thank you.
Okay,
All right,
bye.
thank you. All right, bye.
Bye.
Thank you.
Bye.
Have a nice
Thank
day.
you. Thanks. You too.
Thank you.